people who are leaders.
Who's the greater the effect? So eventually, no matter what your tolerance, you reach respiratory depression, coma, and death. Buprenorphine gives a strong opioid effect, but at a medium level,
A young man who a lot of
other avenue that you see some people
and who have tried.
this is a new day. This is a new day. Lawyers show up and share to the people that are backbone.
We are the lifeguards of tomorrow. We are creating the future by predicting the future.
That the only way you can predict the future is to make it happen.
This is a vision that each one of us can help save ourselves, our family, our friends, our clients, and our patients.
Is to deal with our fellow human beings on this earth with compassion and a recognition that there by the grace of God go I.
Doctor's orders. So the gentleman I'm about to introduce to you, he's half my age, maybe a third of my age, I don't know. All I know is he's been around, and I've known him for a long time. He was a football player, he was a linebacker, and he was a fullback on the other team. It was not something I liked. I was coaching the other team. And I can tell you, in every way, I've known him since he was a child. He has been a fierce competitor. He has been a gifted person. He does everything with passion. He is well known in the media. He's been on several national TV talk shows. In his short life, I probably have socks older than he is. He has been an elected district attorney. He has been a member of our Pennsylvania State Parole Board, and he's here to tell you about sentence advocacy. And where I left off with that, I said, as far as I'm concerned, it's not a lost art. It's not an art at all. We don't have anybody engaged in advocacy as a sentencing, and he will tell you without further ado, and I proudly present to you our gifted speaker, Matthew Mangino.
Thank you, Angelo. Thank you, Angelo. It's certainly a pleasure to be here this morning. I'm going to talk about two areas in which lawyers can advocate for their clients. One is an obvious area, although I think it's expanding, and I think it has to expand. And the other is less obvious. The first is with regard to sentencing, and the second is with regard to parole. And I want to address both of those issues with you today. As Angelo said, I'm a former prosecutor. I was the District Attorney of Lawrence County for 2 terms, and after my second term, Governor Rendell appointed me to the Board of Probation and Parole, where I spent 6 years. And since the expiration of my term on the Parole Board, I've been practicing law, and I've been doing some work in writing in the area of sentence advocacy. My background gives me a unique perspective on this issue, as both having been a district attorney who stood in front of judges countless times and listened to defense attorneys advocate or not advocate on behalf of their client, and also as a parole board member, where I literally interviewed thousands of inmates across the Commonwealth on charges of everything from murder, to burglary, to robbery, to sexual assault. But one of the things that got me to focus on this issue of sentence advocacy was in part from research that I was doing on a book that I was writing. And I'm pleased actually that the book, The Executioner's Toll, 2010, was released just this week by McFarland and Company Publishing House. And the reason, and this is the book actually, and the reason that it kind of piqued my interest about sentencing is, as I wrote this book, what I did was I researched all the executions that occurred in a single year. And the reason that I did that was because I thought that would give us the most unbiased picture of the death penalty. If you were going to write about, some people who support the death penalty write about, terrible crimes and kind of cherry pick all the worst people. Others who are opposed to the death penalty cherry pick those cases that are not so clear, in which they contend that maybe someone who was wrongfully convicted was executed. So I thought the best way to look at the death penalty was to look at a single year from beginning to end, all the cases, good, bad, whatever. And it ended up being 46 executions in 2010. But I also studied the trials, the appeals, and everything that led right up until the moment of execution. And one of the things, that's interesting, certainly about the death penalty, is because the death penalty was ruled unconstitutional in the early 1970s or mid-1970s, states across the country rewrote their death penalty law. And the way they rewrote it to try to make it less arbitrary, as the court had determined, the Supreme Court had determined in Furman, was to have a guilt phase and a penalty phase. And the penalty phase is essentially the sentence. And they made those phases independent of one another. And as the law evolved, we came to learn that not only did you want to have independent hearings with regard to guilt and with regard to penalty, but you also had different attorneys. You had attorneys who specialized in mitigation issues, in sentence advocacy issues, and those individuals would represent a defendant after he was convicted in the guilt phase. So, the sentencing became a very important part of that process. And if you didn't raise issues of mitigation, you were determined to be ineffective in terms of your representation. And as that evolved, the United States Supreme Court basically said that death penalty defendants were afforded super due process. So not only did they have due process, which we're all entitled to, but death penalty defendants had super due process. And that really came a long way from the original decision back in 1932 in Powell versus Alabama, in which the United States Supreme Court said for the first time that someone who's charged with a capital offense was entitled to an attorney. Prior to that, and in some places, certainly in the South in certain circumstances, capital defendants weren't routinely given free legal counsel if they couldn't afford it. But Powell versus Alabama was the first step in that process. And certainly, we're all familiar with Gideon versus Wainwright, which took that Powell versus Alabama issue one step further and said that not only were capital defendants entitled to representation, but anyone who faced the potential of being convicted of a felony and going to prison was also entitled to representation. It actually took the court 31 years to decide that. To decide that everyone facing incarceration was entitled to legal counsel. Prior to that, There was Betts versus Brady and other cases that said that there wasn't really a right to counsel, even if an individual didn't understand what they were facing or were facing complicated charges. But the thing about Gideon versus Wainwright was that it really wasn't a surprise at the time. Although some states, like Florida, where Gideon was charged, were not providing legal representation for people charged with serious felonies. 37 states had a statute in 1963 that said, and that's when Gideon was decided, 37 states had a statute that already provided legal counsel for people charged with felonies. Another 8 states it had been a common practice in that state to provide legal representation. There were only 5 states at the time, Florida being one of them, and the other basically being neighbors of Florida. Mississippi, Alabama, North Carolina, and South Carolina did not provide legal counsel. So Gideon versus Wainwright was not a surprise in 1963, and it was being commonly practiced in 45 states across the country. And legal counsel certainly evolved from there as well. Some 20 years later, in Strickland versus Washington, the court announced what has effectively been the law since, and that is that not only are you entitled to counsel, as Gideon versus Wainwright said, but you're entitled to effective counsel. You're entitled to effective assistance of counsel. And that has been the standard since. What's happened recently, which makes sentence advocacy so important, is the Supreme Court has taken a step further in terms of representation. In the past, thank you. In the past, even under Strickland or whatever standard you applied, what the Supreme Court had said that no matter what happened in a case pre-trial, as long as you got a fair trial, that's all that you were entitled to. And in 2012, the United States Supreme Court took a dramatic departure from that. And what happened in Missouri versus Fry and Lafler versus Cooper was that the United States Supreme Court said that not only are you entitled to a fair trial, but you're also entitled to effective representation in all those matters that lead up to it. And the reason being, as Justice Kennedy said in his opinion, was that 95% or more of federal and state cases were being resolved by plea bargain. And I think his quote was, that plea bargaining is no longer an adjunct to the criminal justice system. It is the criminal justice system. So to say that a defendant who was not informed of a plea offer, who was given bad advice about a plea offer, who was given bad advice about whether or not to go to trial or to enter a plea, wasn't entitled to any protection as long as that defendant went to trial and had a fair trial. And the court said that no longer was adequate. That attorneys had to provide adequate representation at those early stages, whether it's plea bargaining or whether it's the collateral consequences of a plea, which often are overlooked, and attorneys don't advise their clients on those issues. So with the plea bargaining process now a constitutionally protected right, the idea of sentence advocacy becomes even more important in the process. And as Angelo said earlier when he was talking about sentence advocacy, he said, at a minimum, that this information about the background and the circumstances of a defendant should be presented at sentencing. And that's true at a minimum. But really, this process needs to start a lot earlier than the sentencing phase of a case. There's one other case that I think warrants discussion as well in this process, which I think really brings to light how the law is evolving on this issue of sentencing, and that's Miller versus Alabama. Miller versus Alabama is also a 2012 case in which the Supreme Court struck down mandatory life sentences for juveniles. Okay, the Supreme Court didn't say that juveniles could not be sentenced to life in prison, but what the court said was that you cannot have a statute that mandatorily sentences juveniles to life in prison. Pennsylvania had such a statute prior to 2012. In fact, Pennsylvania locked up more juveniles with life sentences without the possibility of parole than any other state by far. There were over 400 people in Pennsylvania prisons who were sentenced as juveniles to life without the possibility of parole. Now there's a whole other issue that's working its way through the courts in Pennsylvania and other states, and that's with regard to whether Miller versus Alabama is retroactive. So do those 400 people serving life in Pennsylvania, are they going to get an opportunity to see the parole board or have their sentences adjusted in some way? Actually, there's the Pennsylvania Supreme Court has made a decision on that case which is not favorable to those people, and that was Commonwealth versus Cunningham, in which the court said in Pennsylvania, the Supreme Court of Pennsylvania said that Miller versus Alabama is not retroactive. But there's a huge split around the country. So there's a number of other states that have said that it's retroactive. There are some federal circuit courts that have said it's retroactive. And actually, the attorneys who represent Mr. Cunningham have asked for cert with the United States Supreme Court. So this issue is going to make its way back to the Supreme Court. But the issue with Miller versus Alabama that's interesting with regard to sentencing is, just as I started this conversation with the idea that the death penalty requires that you have two phases. As I look at Miller versus Alabama, I think juvenile cases in which someone faces life in prison will have to have the same circumstances. I mean, no one's saying specifically that you're going to have a penalty phase for that in those cases and you're going to have a guilt phase, but essentially you are. And I think that the ultimate penalty that a juvenile can face now in this country is life in prison without the possibility of parole. Because Roper versus Simmons, another Supreme Court case earlier in 2004, said that you can't execute juveniles. So the most severe punishment that a juvenile can face in this country is life without the possibility of parole. And if you're going to have a juvenile face life without the possibility of parole, you're certainly going to have, and that's the ultimate punishment, you're going to have to work the same kind of due process that you've done for people who are facing the death penalty. So it's another example of how important sentencing is and how it's evolving beyond death penalty cases in terms of its importance with regard to mitigation. So what I'm suggesting is that mitigation is no longer exclusively the domain of death penalty cases. It certainly will be in juveniles facing life in prison without the possibility of parole, and it's going to continue to expand as we deal with other crimes, regardless of the seriousness of those cases. So what I'm suggesting is that sentence advocacy is kind of the way of the future in terms of in vogue legal issues. So why hire a sentence advocate? And in Pennsylvania, you might say to yourself, well, we have sentencing guidelines, and we know that in every case we look at the history of the defendant and what their prior record score is in the guideline. We look at the seriousness of the offense, what their offense gravity score is, and where the two match gives you a range of sentences. But what's clear in Pennsylvania, in the case is Commonwealth versus Holiday, and actually these written materials will be available from Angelo if you'd like to have a copy of those. But in Commonwealth versus Holiday, 954 Atlantic 2nd, page 6, 2008 Superior Court case says that the sentencing guidelines create no binding effect. There's no presumption in sentencing. They're advisory guidelines. And if you can advocate for your client to be sentenced in a mitigated range, that's perfectly proper, it's perfectly legal, and all that the judge has to do is give a written reason to the Sentencing Commission why he deviated. And you have to be able to present in an articulate and an effective manner why that judge should deviate from the guidelines. Or maybe it's a very serious case in which you're legitimately concerned that your client could be sentenced in the aggravated range of the sentence. So a victory for you might be to get a sentence for your client that's within the guidelines. But the important thing about sentencing advocacy is that the work doesn't begin after you've entered a plea and sentencing is looming, a couple of weeks or a month down the line. Sentencing advocacy begins at the very inception of the case. You need to begin to collect information that portrays your client in a way that might be different than what it looks like on paper. So that history has to begin immediately. Whether it's issues of mental health problems or substance abuse problems or a history of being the victim of abuse. Maybe it's more detail about the underlying crime, but all that information and the work on it has to begin immediately, because ultimately, as Justice Kennedy said, the system is now a plea bargain system. 95% of the cases are going to be resolved by plea bargain. That advocacy has to begin with the district attorney, because that's who ultimately is going to make a decision about a plea. So, if you enter a plea with the district attorney's office without having done any of this research, and then you want to do all this research and present it to the court, well, you've already made an agreement with the district attorney. So sentence advocacy begins at the inception of the case, and it needs to be completed so that when you deal with the prosecutor's office, you can hand a prosecutor or the district attorney a brief, a package, a letter, whatever you want to call it, that explains why your client should not be treated as every other client who's in this particular situation. There are reasons why your client's case should be looked at differently. So that might begin, that process begins very early with collecting the criminal history, police reports, court transcripts, you might want to have this information as early as starting to accumulate that information as early as a bail hearing, at your preliminary arraignment. So the first step is a thorough and detailed interview with your client, not just about the facts of the case in which he or she's accused, but their background, their family history, their criminal history, mental health, juvenile history, drug and alcohol history. There are a number of different areas that you might be able to build on the issue of mitigation. You might want to assist your client in getting some evaluations that would be helpful. Whether it's a drug and alcohol evaluation, there are a number of different assessments out there. One widely accepted assessment that's used in the Department of Corrections and used in a number of courts is the Texas Christian University assessment, in which you're assessed from 0 to 9 to give you an idea whether or not you have drug and alcohol issues. There's a treatment assessment that is available, again, widely used by the Department of Corrections and Parole. It's called the Level of Service Inventory Revised. It's used as a risk assessment as well as a treatment assessment. So those kind of things can, can help. Yes?
Might we be able to help them and the people online to tell them where they can get that assessment?
Yeah. Well,
What to Google or whatever?
Yeah, I mean, they're both of the assessments are well known. So if you Googled the Texas Christian University drug and alcohol assessment, you would find out more detail about it. The level of service inventory revised, again, you would find more information about it. Both of those assessments would have to be provided by a professional who's trained in providing that assessment.
And again, by Googling, they probably could find all of that. And while I've rudely interrupted, anything else, Mr. Mangino, that you want them you're suggesting to them, you can give them a Google reference, maybe a good search word, and don't be reluctant about giving them your website too, or phone number or anything to call, because one of the things we talked about on CLOs is we make ourselves available afterward. Behind you, sir, are all the flags of the various states of people who have been participating online. And I know he has a website, but we have our own Facebook presence now where we network professionals like that, and Attorney Andrew Wilson, who's already passed the flyer out for these people. And you can go through us or through him to find out more information, or if you have a case or something like that, it's great to just be able to get on him. I can't tell you how many times in 28 years I've left the CLE, written something down, and when I needed it, I couldn't find it. So by being aware of that, and I want to interrupt again, you're encouraged to make sure they can get a hold of you.
Yeah, okay, thank you. That's a great idea. And I do have a website in which I write quite frequently on, actually every day, on law and order issues. And I also have an opportunity to write to a wider audience. I have a syndicated column that I write on a weekly basis for Gatehouse News Service, in which is distributed across the country. And I also write for the Pennsylvania Law Weekly regularly, and local Youngstown Vindicator. So if you go online, and my website is www.mattmangino.com. Pretty easy to remember if you can remember my name, and it's MATTMANGINO.com. But you can read about a lot of the things that we're talking about, because I've written extensively on the issue of sentence advocacy for the Pennsylvania Law Weekly and for other organizations as well. And I'm with the law firm of Luxembourg, Garbutt, Kelly, and George in Newcastle, Pennsylvania, and our telephone number is 724-658-8535. Again, 724-658-8535. And you can call me directly if you have any questions, and I'd be happy to answer them. But with regard to sentence advocacy, one of the other important components of it is identifying alternative sentences for your client. And there are a lot of possibilities that exist in Pennsylvania, whether it's county intermediate punishment or state intermediate punishment, looking at the possibilities of work release or county or state probation, a house arrest with electronic monitoring, community halfway houses, drug and alcohol treatment centers, inpatient mental health treatment. Also, if you are incarcerated, looking at and advocating for your client to be involved in therapeutic communities within the Department of Corrections. And also, as a lot of time has been spent here today and during this entire process, and that's pharmacological therapy, which is an important opportunity when you're looking at alternatives to sentencing. The other thing in Pennsylvania that's important when you're in this process of advocating on behalf of your client at sentencing, and that is that the research that you do and the background that you create based on what your client has told you, interviews with him, interviews with client's family, expanding on issues. Sometimes clients are reluctant to talk about issues that may have had a significant impact on their conduct, and that may be the fact that they've been the victim of abuse, whether it's sexual or physical. you may not discover that from your client, him or herself. You may get that information from another family member or friend. So your interviews are not going to be restricted to just your client. Certainly your client's going to provide you the most important information about the offense that he or she's charged with. But when you're putting this package together, that interview process has to move beyond your client and to family members as well. Once you've accumulated all that information, you have to also understand that in a significant number of cases, there's going to be a pre-sentence report prepared by the probation office in most counties. And under the Rules of Criminal Procedure, I think it's Rule 703, you have the right to contest the information that's in a pre-sentence report. So you can say, hey, I want to elaborate on that, I want to provide more information to supplement what's in there, and you're not going to know that if you haven't done this kind of advocacy work on behalf of your client, so that you can challenge inaccuracies that might be in a sentence report, which are important. And, a sentence advocacy memorandum is really shouldn't be looked at as a challenge to a pre-sentence report. So I don't think that's the approach necessarily you want to take. What it is it's a supplement to it. Now, if there's patently false or inaccurate information in a sentencing report, you want to challenge that, certainly. But you don't want to hand your sentence memorandum to a judge and say, ignore that pre-sentence report. This is the information that you really want. I think what you want to do is use your memorandum as a supplement to the pre-sentence report, but something that's going to provide a lot more detail, and more detail than maybe a probation agent, or in some counties it's state parole who does these. They're not going to have the same kind of time that you're going to be able to dedicate to your client. The other thing is, can you have or use an expert in terms of sentencing? And the law in Pennsylvania is pretty clear. The Fry test, generally accepted, standards in terms of using an expert witness. I have testified as an expert witness in cases in the Court of Common Pleas in Pennsylvania on issues of sentencing, on both parole revocation issues and on potential sentencing issues. There is the possibility of hiring an outside expert to come in and also present alternative sentencing possibilities, talk about the issues in terms of research on the impact of mental health problems, drug abuse problems, physical abuse, other issues that could have an impact on sentencing. The most important thing that I would again reiterate is that this process has to begin very early. It's not. I don't think you're doing justice to your client, and you may not even be providing effective assistance of counsel to your client under Fry and Lafler if you haven't done this work very early in the process and used this work that you've done and this information that you've accumulated for purposes of negotiating a plea. The other area that I wanted to talk to you about, and I said obviously lawyers advocating for clients is an obvious part of sentencing. A less obvious area is in the area of parole. Now, the law in Pennsylvania is clear. I mean, inmates are not entitled to legal representation at their parole interview. Okay, and in fact, what the courts have said in Pennsylvania, there's a case, Reeder versus the Pennsylvania Board of Probation and Parole, that basically says that parole interviews are non-judicial, they're not reviewable by appellate courts, they're administrative decisions. And having been a member of the parole board for 6 years, I certainly acknowledge that the process would grind to a halt if every inmate was entitled to legal counsel at their parole interview. But that doesn't mean that you can't advocate for your client in this process. And, one of the things that struck me, in Pennsylvania, there are approximately 51,000 people in state prison. And, every year, thousands and thousands of those inmates are interviewed for parole. And, they're denied parole for various reasons, whether it's a, sustained, long-term misbehavior in prison, whether it's the inability to complete programming or to articulate the benefit from programming. Maybe it's unwillingness to accept responsibility for the crime, lack of remorse, lack of empathy, not having a home plan. Some people are simply disinterested in parole. All those things are difficult to change. So if you go to a parole interview and you're denied parole for a year, so you're not going to have another opportunity for parole for another year, it's going to take you some time to clean up your behavior, to get into programming, to successfully complete the programming, to put together a home plan, a reintegration plan. Those things take time. One of the things that can be immediately addressed is the parole interview itself. How that inmate, how they participated in that interview. Whether they're able to successfully articulate what they've learned and how they've changed. And actually, the interview is a significant part of the process. In 2012 and 2013, the Pennsylvania Board of Probation and Parole cited the interview as one of the reasons, not the only reason, but one of several reasons to deny parole in 1 out of 3 cases. So in 1 out of 3 interviews, that interview, or the way the inmate participated in that interview, had an impact on the parole decision. That meant about 5,500 refusals over that 2-year period had something to do with the interview. So what I'm suggesting is, if we did a better job of preparing inmates for interviews, we could have an impact on the parole process. Because a lot of individuals come before the board, they've completed programming, their behavior's fine, but they can't articulate what they've learned. In fact, countless times I've come into a parole interview sitting at a table directly across from an inmate who I thought didn't even know that there was going to be an interview that day and hadn't given any thought to the process whatsoever. And that didn't mean necessarily that this person didn't learn anything in programming or didn't change in terms of their criminogenic thought process, but they just couldn't articulate it. They hadn't thought about it. No one had prepared them for that interview. We know that high school kids are taught, when you're going to go to an interview, clean up, shave, brush your hair, brush your teeth, whatever it might be. And make eye contact with the person asking questions. Be on your best behavior. Don't slouch down. Those simple things are not taught to inmates. They're not prepared to go to a parole interview. So I think if we could do a better job, and I mean lawyers or other professionals who counsel inmates, if we could do a better job preparing those inmates for parole, we could have an impact on the parole rate. And what I would suggest is that there are ways to go about doing that. as a prosecutor, I know how much time our office spent in preparing a case for trial. We'd spend hours talking to witnesses. We'd spend hours looking at evidence. And I know defense attorneys do the same thing. You know, spending time with their clients, spending time with witnesses. We spend all this time preparing for trial. Then after trial, we spend all this time preparing for sentencing. You know, whatever you might do, whether you're going to present witnesses on behalf of your client, whether you're going to have letters of of support, if you're going to prepare a sentence memorandum, as we've talked about today, all that time spent. That person sentenced, you know, maybe if you really advocated, you know, in a meaningful way for your client, you saved your client from a 3 to 6 year sentence, and instead he got a 2 to 4. And then he goes to prison, and he comes up for a parole interview in which his liberty is equally at stake, because if he's refused, his 2 to 4 year sentence just turned into a 3 to 4 year sentence. We do nothing for them. Lawyers are no longer involved in the process. No one is there trying to tell that individual how important it was, as he did at sentencing, to look good, to make a good presentation, to be empathetic, to be remorseful. That whole process is eliminated. And I think if we can make that connection, whether it's as lawyers still advocating for our clients or others, that we can have a meaningful impact on the parole process as well. And there's no question that, you know, the DOC has spent a lot of time, and the legislature has spent a lot of times on things like justice reinvestment and other ways of looking at getting people out of prison in a timely fashion. They want that. The DOC wants that. The parole board wants that. But I think that we need to fill a void that currently exists, and that is seeing that at least a minimum amount of effort is put into preparing individuals for parole. Maybe not the same effort that goes into sentencing or goes into preparation for trial, but some effort I think is owed an inmate in terms of preparing for trial. And I don't think that it's coddling inmates or that it's giving them an unfair advantage. I think it's helping an inmate articulate what they've learned and how they've changed, and being effective at an interview. But I thank you for listening. I certainly be happy to answer any questions that you may have on either the issue of sentence advocacy or parole preparation. And again, I would ask if you do think of a question or you want to talk about in more detail sentence advocacy, please let me know. I mean, there are a couple of articles that I would suggest that you take a look at, and I'm kind of biased because I wrote them both. But you can find them actually on my website, www.mattmangino.com. But one deals with Miller versus Alabama and the changes to dynamics of sentencing, which was published in the Pennsylvania Law Weekly in November of 2012. And another is reducing prison population through sentence advocacy, which was published in the Pennsylvania Law Week in October of 2012. And actually the written materials that Angela will have a copy of will have both of those articles in them, as well as the other cases that I talked about today. And again, thank you. And if you want to talk in any more detail about these issues, I certainly will be available. Thank you.
Before we go there, Matt, first of all, any of you online, the materials he's talking about, I guess you'll email them to me. So any of you who want them, including people out here, send me your email address and I'll just forward them with your permission.
Yes.
Okay. Secondly, this is our card that promoted our event. We mailed about 700 of those out. This is the flyer for next year's event. We're already into that. And the Facebook instructions, attorney Andrew Wilson has that for you on the way out. And you being a member of our advisory board, at least for now, he can quit whenever he wants. This is last year's event with all of the discs, including your speech, and a directory in there
Okay,
of all the presenters. And we'll give you that. It's in a hard copy notebook if you need anything more. Through the expertise of Dante Ludovisi and Video Standard, he did a great job in assembling all of these. And by the way, these aren't just last year's presentation. These are presentations that have been taking place throughout the year, too. And we'll have the same set for you coming in a bound volume for you that way there.
Okay, thank you.
Okay, and I do have a question for you, though.
Sure.
With regard to the sentence early, quite frankly, we were doing it, we didn't know why we were doing it. We appreciate you telling us that it's probably a good thing to do it. And we've been, as criminal attorneys, we try to get them involved in treatment even before the preliminary arraignment, if possible. I had a case up in Elk County recently. It was a DUI, and this will give you some credence to an application of what MAT stands for. And we were in Elk County, and as you well know, DUI is now a new feature. We find a lot of people everywhere get it on drugs and drug courts. But DUI, for some reason, I believe it's a village moray or whatever, it's a totally different creature. You find very few people when they talk about anything on DUI law. But those of you out there, you may be shocked to understand that no judge in the Commonwealth of Pennsylvania is required to put somebody in the state penitentiary for DUI, no matter how many there are. Most people don't make that argument. The second thing is, most judges, in my Elk County case, we had a case where the lady had 2 DUIs, so we put her in treatment right away, and we were getting no blowback from the DA. We didn't know if anybody was listening to us or we were annoying them. All I know is we kept on preparing them for sentencing from the day we started representing them, which we didn't even know if we would be pleading. So we were doing damage control. Somewhere along the line, we're updating the DA and the judge the whole way along, and of course we supplemented the PSI with our own input, not just the public or the adult probation. We asked that that be supplemented. Nobody's going to keep you from doing that. It's my opinion that judges are looking for advocacy at sentencing, and they're expecting it to come from you. If it doesn't come from you, it comes from no one, because they shouldn't do it sua sponte. Even drug courts, the way they're established, there are criminal defense lawyers raising the roof saying they're slaughtering Sixth Amendment rights because you're diverting people who might have a good criminal defense, because we're still attorneys, right? We always want to push the advantage. So it's very important for you to know that if you don't do it, maybe no one else will or even should. But going back to Elk County, at the end of the day, the 2 DUIs were sentenced concurrently. So that meant that each sentence was running at the same time. The second thing was that the sentence was mandatory minimum of 90 days, but she's doing it in 45 weekends worth work release from now until the... And I'm convinced, without it being said on the record, that it was because the judge believed in her treatment success. And the pharmacology we're talking about, this is my big question for you, and you can do what you want with that point. The pharmacology I'm asking you about is, we know there's a substance called Vivitrol that's non-addicting, and if it does shut the receptors down for 30 days. That's part of what she was being assessed for, and I'll let you develop that point if you want to say anything at all.
Yeah, what I would say is based on experience as a prosecutor. Prosecutors, they can look at cases and they understand when there are issues that may be beyond what the actual charges are and things like that. But what I always found as a prosecutor was that I appreciated if someone came to me and said, here's why you shouldn't treat this person the same way you might treat another person. And it's based on this, whether it's a mental health problem, whether it's a substance abuse problem, whether it's the fact that they're using some therapy to deal with it. You got to give a judge or a prosecutor something to hang their hat on, something that they can say, okay, well, I see now. I see why this case is different than other cases like this. And as Angela said, it's not enough to go in and say, hey, can you give my guy a deal? I know you're offering 2 to 4, but how about 18 to 36? Well, why? Well, because I'm a good guy, and we golf together. Well, no, that's not a good reason. That's not enough. What it has to be is you got to be able to go into that prosecutor who gave your client a written plea offer of 2 to 4 years and say, listen, this is why my client shouldn't get 2 to 4 years. This is, you know, she's got a long history of mental illness. You know, she used, you know, drugs and alcohol to self-medicate. You know, she was physically abused as a child, which you know, exacerbated her mental health problems and made her reach out for drugs and alcohol. And you give that whole history, and look what she's done to try to help herself. It's a continuing battle that she wants to fight, but we need your help to do it. You know, she's not a throwaway. You know, and so if you can make that kind of argument to a judge or to a prosecutor and say, look, I'll have all this stuff, I'll have it in writing, I'll have the research that suggests why, you know, her abuse led to the exacerbation of her mental health problems and drug dependency, and I'll have it for you. You know, and that's what a prosecutor is looking for. That's what a judge is looking for. Not, hey, can you cut me a break here? You know, that doesn't work any longer. And on top of that, I think that as the law evolves after Lafleur and Fry, that kind of advocacy, hey, you know, we belong to the same club, can you help me out today, is ineffective assistance of counsel. And that in the past, those cases couldn't come back to bite you, because all the court said was, if you got a fair trial and, you know, you knowingly and intelligently entered your plea, you have no recourse. Well, that's not the law anymore. The law is that you need to effectively represent your client at that plea process and in that plea negotiation, and make the correct and appropriate suggestions based on the law. And if you don't do that, you're ineffective.
And when we talk about early intervention, we're talking about not only making the argument, but creating the argument, and begin that journey from the day you represent them. And there's an ethical moment here. You're getting an ethical credit hour everywhere. There's an ethical moment here. That client should come into your office. Now, it's my standard practice to say, I am not somebody in the phone book, and the law says I'm supposed to press for every advantage. But I think in today's world that rule requires us to press for every advantage in a hierarchy, and health is even more important than freedom. And I'm telling you right now that I'm going to press for your freedom, but I'm going to press for your health too. And if that ever becomes a problem between the two of us, and maybe you don't want to do it now, or maybe you're going to change your mind later, we need to end our attorney-client relationship. You have to have that disclosure, put it in writing, have their family sitting there. And at the end of the day, I am telling you, I have found 3 things in those 32 counties I've been in. Number 1, I have found district attorneys who say nothing in response to what I'm saying, like I told you in Elk County. But they also said nothing at sentencing either. And that was okay, because I was able to make these points. I have also found district attorneys who are willing to give me a different distinguishing plea offer. And then I've also had a third variation where district attorneys are willing to say, listen, I'm not going to open up some floodgates here, but I will allow you to take my plea and then add that the judge can use his discretion on any mitigators. That last one is one where you can have your cake and eat it too. But you can't argue something that doesn't exist, so you have to create your argument. And I could talk to you a world on this, and I thank you very much. I do have one last question, though, and we know that the state penitentiary, and you're very familiar with that, I always advocate...
Just because I visited there.
Because he was on the parole board.
Okay.
Not because he... Right, okay. Anyway, in the state penitentiary system, Department of Corrections, okay? Now, my research seems to indicate that they have this no medication rule. And that no medication rule kind of starts with the violent addiction that occurs with methadone and whatnot, that maybe they haven't caught up yet. Question, and this is a question, and you can bill me for it. Okay, in the state penitentiary system, one of the ways I argue for DUI defendants to stay home in a local county is that the state penitentiary Department of Corrections does not allow the Vivitrol application. Is that still, to the best of your knowledge, their policy?
Yeah, that's still is their
That's
policy.
unfair, because you've been disconnected for a couple of years.
I haven't been...
But when you left off.
When I left off, yeah. And I think that there's a number of issues that exist there, and that is the cost. which, the Department of Corrections, as you can imagine.
So they would have to pay for it, the family couldn't
Right,
pay
they
for it,
couldn't pay
even if
for
the family offered?
No.
Okay.
And the same thing goes, and insurance doesn't pay for it. I mean,
Well, now we have most insurance
Well,
companies.
I'm saying, but insurance will not pay for
While
you
they're
while
in
you're
jail.
in prison.
Agreed.
Okay?
That's a statute issue, yeah.
Yeah, so, and you can imagine what the pharmacology costs are in a state prison, particularly with regard to mental health issues.
Right.
And now with an aging population, you have a lot of geriatric issues. You have issues of high blood pressure and diabetes. The pharmacological costs in prisons are enormous, and I think, more than anything else, they don't want to add to those costs. But I think it's a process that if over time you can continue to prove, that it might save the DOC money in the long run, or the state of Pennsylvania money in the long run, then it becomes more viable.
And both of us have experience in the political world, and that's something that hopefully will grow with momentum. But in the meantime, that's where we go back to you. Without you attorneys out there online and the people who are going to look at this years, months, weeks from now, without you, that person has no voice. And that voice right now, if you're thinking and you're a sharp advocate, that's the argument you make in front of the DUI judge on why this person needs to stay home, that it might take years before he would ever get treatment. And by the way, that sounds like it runs afoul of the 8th Amendment of the Constitution of the United States. My paralegal and I were just in Virginia in front of the state Supreme Court arguing that very issue on a pro hoc vici. So that's where you need to go. You need to know what the lay of the land is, create the argument, and make the argument with passion. And that's something I've always seen in this young man. I thank you so much for being part of our group. Do you want to say anything else before
Well, I just want to say thank you for keeping referring to me as a young man. That's really nice.
Well, as long as I keep referring to you as young, I stay young.
Okay. So not too many people do that, certainly not anymore. But I really commend you, Angelo, and all of the presenters, because this is such a very important and worthwhile issue. So I commend you for that. And I also, it's nice to be in front of my good friend Dante's camera, because he always makes you look, everybody says that the camera makes you look older and fat, but somehow he makes you look younger and thin. I don't know how he does it.
It's job security. He does it because we keep paying.
All right. Well, thank you. I appreciate it. Thank you.
Okay.